Hi, everybody. This is American Nana, and I hope everyone is doing well. I hope everybody's doing great. I have quite a few opinions on quite a few things, and quite frankly, I'm really curious if anyone can explain to me. I've reached the point of wondering if what Beverly is doing is legal. How can it be legal? Um, She claims that she was a defense attorney, and I did find some cases where one of them was just brilliant, an artist. Yeah, you know, he did the R word. A couple of them, I think, did. I wonder if he ever got convicted later on down the road for actually another one. Anyway, for someone to sit on a bench wearing a black robe that supposedly, I think, don't you take oaths? I mean, I'm confused, and if somebody could help me understand, I'd appreciate it. So, how do I put the question? All right. Um, so you're on trial, and uh, the prosecutor has evidence that may or may not help you. Same evidence may or may not help them. And she finds that since it was a mistrial, the solution is no, it's not a big deal. It's no big deal because, so this time around you have it. Okay, how is that okay? Um, because quite frankly, if it would have been available in the first trial, personally, I don't think we would be having a second trial, which that shouldn't be able to be an answer. Um, how is that possible? How is that even fair? I mean, if you're supposed to guarantee the defense a fair trial, yet you have evidence that I don't know what it's called, but basically, you have evidence that's going to show without a doubt that she's not guilty. So you grab a hold of it and you try to, I don't know, manipulate and hand out here some few and far between pieces of it. But the problem is, how is that allowed? How is that okay? I mean, I didn't watch the, Rusk shooting trial or whatever with, what's his face, Baldwin, but I did watch when the judge called him on the carpet. So, this is how I perceive it should have been. Does that make sense? I don't understand. I don't understand how anybody can keep siding with Canoni, how she can continually do these things. Is it simply because she is in control right now of the case because it's in her court? I mean, don't you have, like, can't the governor step in and say, "This is enough. You're making us the absolute laughing stock of America. Everybody knows this is not how you run a courtroom." This is not how a person gets a fair trial. Things like that. I mean, attorney general. I mean, who is it that's finally going to have enough embarrassment that you step in and say, hold it, stop, this is wrong. And I hope the FBI has Karen Reed's rights have been basically ignored. I mean, how else do you say it? But she's making darn good and well. She's making sure, darn good and well, sure, that the Commonwealth gets their um, trial without ambush. Trying to make it so they get their trial without even having any defense witnesses whatsoever. They've tried to get rid of all the defense witnesses. Yeah, right. No. And also, how on God's green earth can a judge who sees all the evidence, she has seen it through the first trial, she sees it through now, how can she, with a straight face, rule against Easter? How? I mean, we saw the officers on the stand last time, Beverly, and seems to me if the defense got a little bit too um uh, gruff with them, trying to get them to spit out the words that no, this is not how an investigation should work. Just made it look like he was, being that way for no reason. I mean, what is the deal? What what is the deal? I don't get it. How is it legal? How has nobody stepped in and said, "You better back off"? I'm baffled. Is it just because you're in Massachusetts, or is this how it's going to be in other areas where judges have been on the bench so long and allowed to get by with so much that you think you can just blatantly disregard the right thing to do? You need to look in the mirror and you need to ask yourself, when did your bias become so bad that you are not an effective judge on this case anymore? You can't be. Because because you can't seem to rule in favor of the defense for anything. And you're going to let a dog behavioral specialist testify with no voir dire. We didn't have an evidentiary hearing last time. We're not going to have an evidentiary hearing this time. And the Commonwealth can voir dire anybody they want to, but the defense isn't allowed to because why? Because you think that they meet the criteria to be an expert. I don't know how a dog behavioral person can become an expert in dog bites. I mean, can tell you what he thinks would cause a dog to bite. I can tell you what I think would cause a dog to bite. He can also tell you what would cause a dog to bark. Well, I can pretty much tell you that too. Difference is, I'm going to say that Chloe would have been barking from the entire time that John O'Keefe was laid out on that front yard, regardless of who did it. She gonna be going crazy. I'm sure that your behavioral specialist will disagree with me, and the reason I say that is because, well, that would kinda discredit the Albert sleeping, but then Chloe probably left the home that night, and then Caitlin Albert swearing under oath that it was always the plan for her boyfriend to pick her up, and he said under oath, "No, it wasn't always the plan." She called, wanted to come home, wanted him to pick her up, and even though he was trying to sleep before he had to go work and plowing the roads, she's high maintenance, so he just went and picked her up. Didn't ask anything, doesn't know the time, doesn't know the day. Surprised he can tell you that he knew which car he drove because he sure didn't remember a thing. But he did say that. Where's that? Why wasn't that? I mean, that was a huge lie, and for what? Beverly, don't you see everybody on the Commonwealth side gets up there and ends up lying out their rear ends? Why? Why are they lying, you may ask? You know why. It needs to stop. It needs to stop. We're on the eve of trial. April 1st, April Fool's Day, on you, Beverly, for starting this trial on April Fool's Day. As if your bias doesn't hit us in the face every single day that you sit on that bench. Hmm. Let's see if we can find any judges that know how to handle certain situations because Beverly, I think you're in a situation that's just over your head. You should recuse yourself. It's too complicated. You can't possibly separate yourself from your cronies. And I don't care how you look at it. I don't care how you say it. You've been there a long time. Don't even try to tell us that somebody ain't pulling string and that you're not jumping. Who? I don't know. Why? What, maybe they got some dirt on you. I mean, I'm assuming Chris Albert has dirt on just about anybody he wants if they've stood outside D&E Pizza waiting to go into McCarthy's because they're not going to go eat at D&E Pizza, but he can get all kind of earshot full of stuff and he can have a lot to say about it, can't he? Don't bother you, does it? Mm-mm. They probably got you or somebody you know, or can you imagine how many people they can hold that over their head? Something happened and they can hold it over their head, get what they want. You got all kind of problems up in there. And the police audit is the in my opinion, is the only reason any of this came to light. And it was the town of Canton that was begging for an independent audit of the police because of this case. And then Beverly, the other thing is that you just, you know, one thing that you overreacted to regarding the defense witnesses, and you think that just gives you just the right to just be a jerk to them the entire time. You really let everybody down there, don't you? Because it's just not right. But I have no background in the law, so I don't know. But I'm flabbergasted. I'm past gobsmacked. Okay, I don't know, flabbergasted, gobsmacked, walking around in shock, living in the twilight zone is how I feel because I just can't understand. I can't understand how you got to where you are in this case. I can't understand how you didn't look at the evidence in the first trial and say, "We don't have enough to go to trial. Are you kidding me?" Because So much of it's just based on hearsay. And even though nobody's called it out loud enough, apparently, Proctor decided Karen Reed was guilty prior to ever going to her dad's house. And he determined that simply by speaking to Matt McCabe, Jen McCabe, and Brian Albert. He didn't have any evidence ran. He had nothing. He had nothing. Now, when they did get her car, they were able to tear up her infotainment center. They never took pictures. Nope, never took pictures. So I don't know. You know, I mean, for one, if I'd have had a tail light busted all to Hades and back, and it was my murder weapon, don't you think for 5 seconds I'd have had 1,500 pictures of that tail light before you could ever say that I confiscated it? Your law enforcement have no problem sitting on that bench, I mean, sitting on their witness stands after taking an oath and lying or not having a memory of something. Either way you go, this is wrong. I wish somebody in Massachusetts would come and just escort you on out there and tell you that for your behavior in this courtroom on this particular case, in all fairness, in everything that's right, they can't allow you to continue to sit on that bench. Somebody has to have the right to do that. And whoever that is going to look real bad as this keeps going because people are irate. The world is irate. Okay, hold on. Okay, so what I'm going to do is I'm going to play just a bit to show you her behavior. And you know, she acts like Brennan in so many ways, so cocky and sure of herself. And this judge is fantastic. Y'all, let me say that she she might actually act more like Beverly because no matter what's said, she thinks she's in the right, even though she's clearly in the wrong. So let's just watch a few minutes of this. I just love this judge. This judge just
and this is the best evidence against Hannah Gutierrez.
Yeah, you said that a couple of times. Any favorable evidence you understand as a prosecutor has to be turned over to the defense, correct?
I do.
Any evidence that could be used as a defense to potentially be favorable has to be turned over to the defense.
Absolutely.
So the third Hague report that never got turned over to the defense, you understand that that's Brady evidence?
I did, yes.
Okay. And you also failed to turn that over in this case as well, correct?
And let me give you a full answer to your question. When the second Hague report came in, and I provided all of this to the defense, I sent it to the person who is managing the discovery server and asked them to upload it. It wasn't until I realized during pretrial interviews that it wasn't there, that there was a problem with it. So I then attempted to figure out what the problem was, and it was indicated to me that it appeared that the former paralegal who was working for the special prosecutor had removed it. So we then immediately provided it. Then during the pretrial interview of Mr. Hague, it was brought to my attention that the defense did not have the August 31st report that indicated that the gun functioned fine, perfectly fine, and that was provided immediately. I went back, I checked my email, I could see that I received it from Mr. Hague and failed to forward it on to be uploaded. And I provided it as soon as I was aware that You did not have it.
The fact that nobody at the Hannah Gutierrez retrial.
Does that sound kind of like Proctor had the videos, but he had them in the case file, but the case file probably was under Barney Rebel for all we know. And then he just assumed that, you know, even though the defense continually asked for production of any evidence, it was never turned over. And watch her, she I swear that oh my gosh. So I think that they took a few lines out of this for whatever purpose to show. I mean, the telephone game is big in Canton. If your arse is not calling somebody else's arse, then it's stuffing reports places where they don't belong, in drawers where they can't be seen. I mean, the ghosts that run rampant in Canton doing things that help the McAlberts out are amazing to me.
Cross-examine Mr. Hague about the report didn't clue you into the fact that nobody had the report?
Actually, it didn't, and I'd like to address that. The reason that it didn't clue me in is because Hannah Gutierrez's defense was that the gun worked perfectly. The defense in Hannah Gutierrez was never interested in any evidence that there was an issue with the gun, because if there was an issue with the gun, it damaged her case. So what you could see, if you watched the trial or saw any of the transcripts, the defense actually brought in their own expert to say that the gun worked perfectly. So they had no interest in that information.
And actually, you elicited testimony from Mr. Hague at that trial that was inconsistent, at least partially inconsistent, as the court's aware, with his third report, correct?
Tell me what you're referring to, and I'll answer your question.
Well, there was a whole hearing about this where you saw this, and you saw me go back and forth with Mr. Hague for 25 minutes. So
I agree, but I need to know what you're talking about for me to answer your question.
Okay, if you can't answer the question, you can't answer the question. I'll move on.
I'm happy to, but
You say that the extent of the communications you have about the doc report, as you relay it to the court, is that all you said in response was, "Great, do that." That's your testimony?
yeah, I assumed that it was going to be tied to the same case number. So I said, great, do it, file a report.
No follow-up questions?
No, because I had a picture of the ammunition that didn't match the ammunition from the set of Rust.
No concerns in your mind when you got the case file and you turned it over to us and it wasn't included?
Absolutely not. There's a terabyte of discovery. I didn't know whether this 2-page police report had been provided. And in addition to that, I had no reason to believe, and still have no reason to believe, that those rounds have anything to do with these cases.
As I asked you about Mr. Hague yesterday when Ms. Popple testified, you would agree with me that her testimony under oath was false?
What part of her testimony was false? And I'll answer.
That she said that these rounds don't look anything like the rounds on the set when you elicited that testimony.
I agree with you. And I didn't realize that there were rounds that looked like that.
It's okay. In any event, when the court, and you never tested those rounds either, correct?
Any of the rounds that came from Mr. Teskey? No, because they came in just a few months ago.
And the court asked you actually one question that I want to address, which is the court said to you, well, what's interesting to me, to be quite honest, is that yesterday you didn't even want to do a written reply. You wanted to just give an oral response. And what you said to the court was, I never saw these. I've never seen these. And I never saw the report. I have absolutely never seen these until this morning. Do you remember saying that to the court?
With regard to the 3 Starline brass, with regard to the 3 cartridges that appear to be similar to Rust, yes.
Well,
I never saw them until today.
Well, but you said also, I never saw the report, right?
I never did.
Right, but don't you think, given your duty of candor to this court, that that's awfully misleading to not tell the court at that point that you knew about this when it occurred long ago?
That I knew about what?
You knew that Mr. Teskey had turned in this evidence, that you knew that the report would have existed because you just told this court that the doc report was okayed by you.
Sure.
Don't you think it was misleading to this court to not just say at that point, just so you know, I know about this. I knew about this then. I was involved.
I did not intend to mislead the court. My understanding of what was dropped off at the sheriff's department is on this computer screen, and it looks absolutely nothing like the live rounds from the set of Rust.
The truth of this matter is you don't like Mr. Baldwin very much, do you?
That is absolutely untrue. I actually really appreciate Mr. Baldwin's movies. I really appreciated the acting that he did on Saturday Night Live, and I really appreciate his politics.
Wow. Really? I don't know if I ever saw him in anything that I really cared for myself, you know. But she's something else. All right, let's see.
You told one of the witnesses who disagreed with you during an interview that you thought Mr. Baldwin was a cocksucker.
I do not recall saying that. I know that that was something that Mr. Baldwin would say on the set of Rust. I don't recall saying that.
Do you deny that under oath?
Without having more information, I can tell you that I do not recall ever saying that. And if I did say it, I invite you to point it out to me.
You called him an arrogant prick to another witness.
To who? To what witness?
I'm asking you, did you call him an arrogant prick during a witness interview?
I don't believe I did. I don't recall.
You deny that?
Without knowing what you're talking about, all I can tell you is that I can't respond if I don't know what you're talking about.
And you said also to witnesses that you would teach him a lesson.
I never said to witnesses that I would teach him a lesson. Absolutely not. In fact, Mr. Spiro, I want to give a full response to your question. I made every effort in this case to resolve this case with your client in a very favorable way for him.
All right, I'm going to move to strike this. It's not
And she really, really thinks highly of herself, doesn't she?
responsive.
It is
Well, I don't want
responsive.
to talk about plea negotiations.
Yeah, and it's not responsive. So I have no further
All right, do you have any follow-up testimony? All right,
I want to say I have no recollection of calling him any of those names. I have invited the defendant to tell me what he's talking about, and he has declined. I want the court to take notice of that.
Oh, court, take note.
thank
Take
you.
note.
You may step down.
It's against me. It's against me. And I am the
All right, any
special
other witnesses?
prosecutor.
No, Your Honor.
All right, argument, let's not, 15 minutes aside sufficient?
I don't even think that is necessary, frankly.
Do you wanna make argument?
Further argument.
Nope.
All right.
I don't think you decide any further argument on this one.
All right. So dismissal with prejudice is a very extreme sanction. And case law is very clear that because it's very extreme, I have to go through.
I hope Beverly, you up there in Massachusetts where your police officers don't know how to do their job in the snow, I want you to listen very carefully to what a real judge would do.
Through every single element, and I have to make a very good record as to why I'm seeing what I'm seeing. So in order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, the evidence was favorable to the accused, and the evidence was material to the defense. So let's go through the elements. Suppression of evidence. The definition of suppression of elements, this is Case versus Hatch, is while the first element requires proof that the prosecution suppressed or withheld the evidence in question, it does not require a finding of bad faith or any other culpable state of mind on the part of the prosecutor. This prong is satisfied. The Santa Fe County Sheriff's Office and the prosecution failed to disclose the supplemental report to defense and provide defense an opportunity to inspect the rounds collected into evidence that Mr. Teske gave. Is the evidence favorable to the accused? The second Brady element is whether the suppressed evidence was favorable to the accused, either as impeachment or exculpatory evidence. This prong is satisfied. The suppressed evidence is favorable to the accused. It is impeachment evidence, has even been offered in this trial as impeachment evidence, and is potentially exculpatory to the defense. Critically, the exculpatory value cannot be analyzed at such a late juncture because of the non-disclosure.
I don't know any of these people. I know that's his wife right here, but I don't know who this lady is that's crying.
Is the evidence material? While post-trial discovery of evidence under Brady requires a reasonable probability that the result of the proceeding would have been different, discovery of evidence during trial requires an evaluation of whether the late tender has impeded the effective use of evidence in such a way that it impacts the fundamental fairness of the proceedings. And that is State versus Huerta Castro.
Did you hear that, Beverly? Did you hear that? Beverly, are you listening? Because if they had a video of that vehicle going in to the Canton Police Department before anybody could get their hands on it, or a photo and it was presented, guess what? It wouldn't have gone to court because Karen Reed did not hit Officer John O'Keefe. You see, even when they put that taillight together on a stand, it was missing a small piece. A small piece, Beverly, a small piece. You know, you know what's on that video. That's why they won't turn it over. You know, Beverly used to be a defense attorney. I bet all you did was do the scumbags of America. Nobody else would hire your arse.
This evidence is material. The late discovery of this evidence during trial has impeded the effective use of evidence in such a way that it has impacted the fundamental fairness of the proceedings. The defense is not in a position to test the state's theory as to the source of the live rounds that killed Ms. Hutchins. I'm also going to take a look at Harper, State versus Harper. The assessment of sanctions depends upon the extent of the government's culpability, weighed against the amount of prejudice to the state, quoting Chenard. Let's go through culpability. Our case law generally provides that the refusal to comply with a district court's discovery order only rises to the level of exclusion or dismissal where the state's conduct is especially culpable,
Look at
such
it.
as where evidence
Look
is
at it.
unilaterally withheld by the state in bad faith, or all
A
access to the evidence is
yacht.
precluded by state intransience. The state is highly culpable for its failure to provide this discovery to the defendant. The state unilaterally withheld a supplemental report. Santa Fe County Sheriff's Officer made the decision, and apparently also with the prosecutor, pursuant to Hancock's testimony, that the evidence was of no evidentiary value and failed to connect the evidence to the instant case. The case agent, as well as pursuant to Hancock's testimony, Ms. Morrissey, was aware of the new evidence and yet did not make an effort to
Morrissey.
disclose it to defense.
So fitting.
The state's willful withholding of this information was intentional and deliberate. If
Probably
this conduct does
related.
not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching. Prejudice. When discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defendant's preparation for trial.
Okay, Beverly, that's trial 1.0. Just because there's a retrial and you want to say, oh, it can be fixed during this. No, Sugar Plum. We're talking about trial 1.0, what you should have done. What you should have done. You should have done that when they turned over in the middle of trial that the video from the Sallyport. You didn't care. You didn't care when you were told by Attorney Yannetti that that piece of garbage Proctor sat up on that stand and lied under oath about him being at that school. You didn't care.
The court concludes that this conduct is highly prejudicial to the defendant. The jury has been sworn, jeopardy has attached, and this disclosure during the course of trial is so late that it undermines the defendant's preparation for trial. There is no way for the court to right this wrong. Lesser sanctions.
Beverly?
Under Harper, trial courts possess broad discretionary authority to decide what sanction to impose when a discovery order is violated, State versus Lemire. The sanction of dismissal is the only warranted remedy. The jury has been sworn, jeopardy has attached, and a mistrial would not be based upon manifest necessity. Further, the sanction of dismissal is warranted in this case. The state has repeatedly made representations to defense and to the court that they were compliant with all their discovery obligations. Despite their repeated representations, they have continued to fail to disclose critical evidence to the defendant. Brady and Harper are satisfied. Dismissal with prejudice is warranted. Court also has power, inherent power. Per State versus Lemire, where discovery violations inject needless delay into the proceedings, courts may impose meaningful sanctions to effectuate their inherent power and promote efficient judicial administration. The state's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted. Now, with respect to the jury, I don't imagine you all want to return on Monday. I will take care of the jury.
Thank you.
We are in recess.
Thank you. See there, Beverly? That's how it's done. And even though all this garbage that keeps coming out, all this new evidence should have been given to the defense on the first go round. That is the problem because it would have definitely helped the jurors make the correct decision. Don't you think, Beverly? Hmm. All I can say is I I do believe in karma. I am curious though. I mean, I've heard that Beverly Cannoni's father was a judge. Was he also one that would compromise morals as well? I'm going to guess so, because otherwise, how could you stain his name as well? Because that's where it's going. None of you, none of you are worth any salt. Now, the right thing to do, Beverly, would have been to dismiss all charges and to publicly state that you really aren't such a stupid person to believe that the Commonwealth would have evidence that would help the Commonwealth and not have given it. Nobody believes them, and they get up on your stand and lie, so why bother calling them? But this judge stands for justice. She is an honorable judge. She maintains her oath. People can feel confident if they ever go in front of her. You, on the other hand, yeah, I better not say what I think because it could be misconstrued and I could maybe be in trouble. Because my thoughts are pretty, they're pretty out there. But then again, I don't think you deserve anything other. Toodles. Thank you. Y'all have a good night. I gotta go find the information on Judge Beverly being sued over the supporters of Karen Reed. I guess they got them down in Timbuktu or something. But I don't know how much weight it carries because they also had some of the businesses. I don't know. But I'm gonna go find that because I'm so curious if I can find it behind anything not being a paid. Bye.